Hello and welcome to the big picture. The opinion of the Supreme Court's 5-member bench headed by Chief Justice S.H.Kapadia following the presidential reference on the allocation of natural resources yesterday has clarified that all natural resources need not be auctioned. This clarification coming in the light of the earlier order that 2G spectrum should be auctioned afresh has brought relief in the government circles, especially since it faces strong criticism and charges of huge losses and windfall gains in the coal blocks allocation through the screening process. While the government sees this opinion as a vindication of its stand on coal block allocation, opposition parties are not, however, convinced. While some feel that auction is the best policy, others have raised the fundamental objection to privatization of natural resources. Today we will look at all this while asking the question if the Supreme Court opinion provides clarity for future allocation of natural resources. To discuss this, I have with me an eminent panel of guests: Salman Khurshid, Union Minister for Law and Justice; Vikas Singh, former Additional Solicitor General of India; B.K.Syngal, former Chairman and Managing Director of VSNL and a telecommunication expert. Others will be joining us very soon. Welcome to all of you. First, let me go to Mr. Salman Khurshid. Mr. Salman Khurshid, today you three of you held a press conference. There was a sense of elation almost, which we felt when we looked at you addressing that press conference. Do you think that this opinion of the Supreme Court has vindicated the stand of the government in the coal allocation also?
Well, of course it has. I think there's no doubt about that. We had not the slightest reason to believe that the judgment was anything but this. But of course, the opposition were not willing to accept, and that they kept throwing all kinds of barbs at us. I hope that they will now at least be satisfied. It's not just one or two judges; it's 5 judges who've pronounced, and this is part of the political and legal ethos of our country, that if the Supreme Court pronounces on something, then we must end the debate there.
There is no constitutional mandate to go in for an auction. This is what the Supreme Court opinion says. But isn't it ironical that the same Supreme Court had said that in the 2G case that only auction is the best option?
No, it's not a question of the same Supreme Court. It's one bench of the Supreme Court that pronounced specifically on the issue of spectrum. And we said we don't want to reopen that question. We're going ahead with an auction. And it was on that very clear understanding that the larger bench, which is a bench of 5 judges headed by the Chief Justice, examined the broad principle and larger issue, keeping this aside. And we have no problem that this is something that's going ahead. The auction will go ahead, and will go ahead as directed by the Supreme Court division bench. But as far as the larger bench is concerned, that was for the broader principle of general application, universal application, and we are very happy that public policy, the domain of public policy has been left to elected governments and to Parliament.
It's very interesting. One more question to you, Mr. Khurshid, before I go to my other guests. The BJP leader of opposition in the Rajya Sabha, Mr. Arun Jaitley, has been quoted today as saying that his party still believes that the auction is the best option for all natural resources except water and air. So you will still have to face some kind of resistance from the opposition parties.
Well, I think the Supreme Court has made it clear that people can believe what they like, but it's the government of the day that has a right to implement what it believes. And I think that's a democratic principle that I hope Mr. Arun Jaitley and everybody else will not be able to cavil with or to question. That ultimately it's the government of the day that must decide what to do, and not the opposition. And the court says the government of the day has a right to decide. You cannot necessarily expect everyone to agree, nor do we expect everyone to agree. We try to persuade everyone, but if everyone doesn't agree, it doesn't matter. It's the government of the day that must decide.
Okay, let me go to Mr. Vikas Singh. Mr. Vikas Singh, do you think that this opinion of the Supreme Court has clarified all the matters which were, about which there were a lot of confusion so far.
Actually, if you ask me, Salman may have hesitation in saying, because he is a law minister of the country today, and the government had filed asked for a presidential reference on a very limited point.
Yes.
But if you ask me, the reasoning of the Supreme Court, the natural resources would apply even to spectrum. But unfortunately, in the presidential reference, the judicial propriety did not demand that the government could have gone in a presidential reference on a matter which had been adjudicated. So they had to take the route of the presidential reference, only leaving aside spectrum, because spectrum, if they wanted really to question the judgment on spectrum, they had to go for a review which had to go before the same bench, and if the bench decided against them, then they had to go for a curative petition.
Right.
So really speaking, it is a decision for all natural resources, including spectrum, because spectrum is no different commodity as a natural resource. But I have a slightly different point to make.
Yes.
The policy making is such in such matters and such economic important matters, that if you were to allow a natural resource to go to the commercial, for commercial exploitation to a private party, and if you were to not charge him that money, initial money, he is bound to pass it, because he is operating in a competitive environment. There are 7-8 private operators at any point of time, and he has to win over the others' customers. So he is bound to pass on this, whatever you don't charge, to the people of India. Unfortunately, the people of India have not been heard. It is only basically either the operators on one side and the government revenue on the other. Whereas if the government were to collect this revenue, it is suspect as to whether this revenue will actually reach the people in the manner in which it should reach. So, really speaking, it's a perspective which is a policy perspective, and unfortunately the government could not elaborate on this at any point of time, that if you want to give a natural resource to a industry which is considered to be providing infrastructure to the country, and if you do it in a competitive environment or in a regulated environment, here it is both. I mean, It's a policy of forbearance at the point of time, because the TDSAT says that we want you to decide, because there are so many players, the players, the competition will itself bring down the tariff. So either it be a regulated environment or a purely competitive environment. If you give it to a private operator for free, that doesn't mean that the people of India are being, not benefited.
Right.
It is ultimately going to reflect in the tariff which the people of India are going to pay. Now today what is happening? Today now the tariffs will rise. Firstly. Secondly, you are seeing how mobile phones calls are dropping every day, because capital investment is not coming in the sector. So all this uncertainty which has been created in the sector, ultimately the people of India will be the sufferers. So you pay today for a call of 2 minutes, actually you are able to talk only 1 minute.
Okay.
And the tariff also is going to increase, because you're not able to talk, the call drop takes place.
No, Mr. Vikas Singh, you're making very interesting arguments. On the one hand, you are accepting the fact that, this judgment, this opinion of the Supreme Court giving this wide, freedom to the government of the day, to the executive, to decide which is the best option. And on the other hand, you are saying that 2G auction, the Supreme Court having asked for renewal of auctions or fresh auctions, that will cost us and the common man a lot. Anyway, I'll come back to you. I'm joined in the studio now by Paranajoy Guha Thakurta, a senior journalist and a commentator. Welcome, Paranajoy. Paranajoy, Vikas Singh's arguments are very interesting. What is your take on it?
Okay.
He said,
my take is that this Supreme Court judgment, which runs into all of 208 pages, is like that proverbial elephant, and we are like the blind men. We touch a different part of the elephant, and depending on what we want to believe or not believe, it becomes something. I think somewhere along the line, all of us, maybe I'm also guilty of that, we are missing the big picture. The government wants to pat itself on the back. It says its position has been vindicated.
We have someone.
I know, I'm aware of that.
Yes.
And it's in a veiled manner critical of the Controller and Auditor General without naming the CAG. It's talking about constitutional authorities.
Right.
But the way I see it is that there were 5 points on which the presidential reference was made.
Right.
4 have not been talked about, 1 has been talked about. What is that? And I would urge you, and I would urge everybody to read the full judgment, in particular the last 60 odd pages where Justice Khehar 'Khehar 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 ' the reference was under all circumstances, all natural resources should be allotted only by auction. The answer is clearly no. And he gives an interesting example is out of 100 natural resources on 100 occasions, if 99 you said auction, but one case you don't say auction, still your answer is no. That is the way the reference was framed.
Absolutely.
Having said that, I think what the judges of the Supreme Court have clearly mentioned is the issue of public interest, the issue common good, correct, and the whole issue of balancing common good and public interest with revenue maximization.
Right.
Most importantly, it's talked about transparency, fairness in procedures.
Yes.
Now, it's interesting that both in the case of coal and in the case of spectrum, the government continues to justify giving out these scarce and precious natural resources at a low price on the ground that it's going to benefit the consumer.
It has benefited the consumer.
1 minute, 1 minute.
That's what
now, this is a contentious issue. In the case of coal, has the price of power, the price of cement, or the price of steel come down? Answer no. In the case of telecom,
none of the power projects have even
whatever may be
taken
the
shape.
reason, we can talk about the reason. In the case of telecom, the new players who entered, whose licenses have been cancelled and are now going to be re-auctioned, what is their share of the market? Can you tell me? Is there been an intensification of competition to benefit the consumer? And this is interesting because Mr. Vikas Singh is also agreeing with this point, that at the end of the day, the consumer in whose name you are giving away these scarce natural resources at a throwaway price or next to nothing or free has not been the beneficiary. The government, which is supposed to act as a custodian of resources that belong to the people of the company, to the country, I beg your pardon, has it been a fair adjudicator? Has it been a fair custodian? Has it been transparent? Has it done any of it? So it's all very fine to say that, look, the government has vindicated our position and not that of the CAG, that under certain circumstances you need not auction a natural resource. But if you go through the text of all these 200 pages, what the Supreme Court has clearly said cannot be seen by the government as a vindication of its position, or it should not really be patting itself on its back.
Mr. Salman Khurshid, the Paranajoy's description of blind men and the elephant, as far as this judgment is concerned.
Well, it's fine. It's fine. Descriptions don't make the law. The law is made by the actual pronouncements, and we are not going to be told now that we have to go back to nursery school to understand how to interpret judgments. And I think he's been influenced, as he's just said, by 60 pages, largely by what is an additional pronouncement by Justice Khehar. But that is not all. Justice Khehar has said that I agree with what has been said in the main opinion of 4 judges. And if at all Justice Khehar's judgment was found to be departing from what the 4 judges have said, then it would be a majority of 4-1. So I don't think that we should be grasping at straws to somehow find that the government is not vindicated. Of course, there is a lot in it which indicates how the government should proceed, but the decision about what is the right thing to do and what is the right economic analysis to apply, that decision very rightly by the court has been left to the government. And no matter of any amount of screaming and shouting is going to help anyone to say, no, that is not left to the government. That still has to be done the way we want it done.
Okay. Anyway, that's an interesting argument, but there are much more things in this judgment which we need to discuss. Before that, let me go to Mr. Syngal. Mr. Syngal, interesting points raised by both Salman Khurshid as well as all the 3, in fact, Vikas Singh and Paranajoy. What is your take on the effect of this judgment on the 2G spectrum issue?
Mr. Nikam, first of all, I would like to clarify that no license with spectrum or spectrum has ever been given without either bidding or an auction.
First come, first serve.
First come, first served was a creation in 2005.
Right.
Otherwise, ever since 1994, when the liberalization started, it was bidding, and I think people are confusing between bidding and auction. 1995, it was bidding, and in 2001, it was an auction. 2001, it was an auction, very successful auction.
Right.
And what did it result in? 7,000 crore rupees, 4 licenses were sold, and today the revenues are about in excess of 200,000 crores per year. So therefore, to say that licenses were given with spectrum or spectrum was given on first come first basis is completely wrong, and it's complete misinterpretation of what has been going on.
No, that was concerning a specific time period when the first come first serve policy, the 2G judgment of the Supreme Court concerns that specific period of time.
There never was a first come first serve policy. Let us be very clear about it. Never.
Mr.
Since
Raja,
1994.
Mr. Raja,
and in 2003, there is a cabinet approved policy.
I'm talking of 2007, Mr. Syngal.
I am coming to that. In 2003, there is a cabinet approved policy that going forward, 5th and 6th licenses will be by auction, as was done in 2001. So there never was a first come first served policy.
Okay, now let us come to the judgment. Let's come to the opinion of the Supreme Court, yesterday's opinion.
Yesterday's opinion
Yes.
doesn't say, if I read page 47 of Justice Singh's observation, he has said perhaps the best method for doing so would be through a duly publicized auction conducted fairly. And also towards the end also, in the last paragraph, the same sentiment has been repeated. So it is not a question of that auction is not the best or the prices can go up. Did the prices go up, price or the tariff went up when Vodafone paid $11 billion for the license which they bought from Max? The tariff went down because the competition came. Technology came.
Mr. Syngal, so what is the point? What is your point which you're trying to make? Do you agree with what the Supreme Court opinion has come out with yesterday? Do you think that this flexibility which is being given to the executive to decide whether it should be an auction or any other method which they should employ, that is what the Supreme Court, do you agree with that opinion of the Supreme Court?
The opinion of Supreme Court is auction is one of the options. And
right.
It has to be transparent, it has to be fair,
Absolutely.
It has to be equitable.
Right.
And it has not to be the way it has been done on an arbitrary first come first served basis.
Okay.
The Supreme Court doesn't say that auction is not a way forward. The Supreme Court clearly says perhaps. The word is perhaps. So therefore the only observation made is that rather than giving as a constitutional this thing which was given by the two judge bench,
yes.
It is now the bureaucracy and the elected members
right.
who can decide.
Okay.
Otherwise, if the business has to go on, auctions and that in a transparent manner is the best way forward. And I do not agree the tariffs will go up, because the tariffs will not go up because 7,000 crores in 2001, halfway through the license period, are today producing 200,000 crores worth of businesses.
Okay, Mr. Syngal. We need to go into a short break now. Please keep watching. We'll be back very soon and continue this very interesting discussion. Welcome back. We are discussing the opinion of the Supreme Court on the question of allocation of natural resources and asking the question, has this opinion, or rather will this opinion lead to clarity in allocations of natural resources in future? Mr. Salman Khurshid, this is the question. Will this opinion lead to some clarity as far as the executive, as far as the government is concerned, and how to go about distributing natural resources? Now, for instance, when it comes to the issue of land, is auction the best policy?
Well, this is not something that I can pronounce for every department of government. The principles are very clear now.
Yes.
Public policy area and domain of public policy, that is to be taken care of by governments. That's made very clear. Obviously, the usual things about transparency and integrity and
common good,
equity, etc. Those have to be there, and
common good.
they will be there. Common good, of course, common good is what governments are for. But at the end of that, applying all these guiding principles, what will be in the circumstances before any ministry, and given the objectives that they put down in the plan, what is the decision they will take, we will know from time to time. It's not something on which a cathedral pronouncement can be made by any person on behalf of government at this point of time. But let me just say one thing.
Yes.
I'm a little amused by the fact that every time somebody wants to give an interpretation of this judgment, if they're not entirely happy with this judgment, they go to Justice Khehar's pronouncement. Now, what about 4 other judges that have said something? Justice Khehar's judgment is a good judgment. He has agreed in the beginning and the end with the opinion of the 4 colleagues of his, but then he has gone on to say some other very interesting things that I think we should take with the utmost of respect.
Right.
But you can't ignore the opinion of 4 judges and then base everything you have to say on some paragraphs of Justice Khehar's judgment.
Okay. Salman, the question now is, do you think now the governments will be more free to come out with their policy decisions without much hindrance from the judiciary, that somebody goes right at, even in the midst of a policy being taken and policy being implemented, going to the courts and getting stay orders? Or do you think after this opinion there will be that much more freedom to the government?
Well, I think there will be legitimate freedom to the government, constitutional and rational freedom to the government. But of course, a lot will depend on judicial discipline. This is a pronouncement of 5 judges.
Right.
And obviously, everybody in this country, including the Supreme Court benches, are bound by the pronouncement of 5 judges, unless there were 7 judges that were to take another view.
Right.
So the pronouncement of these 5 judges, headed by the Chief Justice, will hold the ground now. And I think it's important that all of us, instead of finding ways and means of bypassing it, we should honestly and sincerely and with as much objectivity as possible try to observe the guiding principles that have been laid down in this judgment.
It is very interesting, Mr. Salman Khurshid. Today, during the press conference which you and the 2 other ministers held, you brought in the issue of this presumptive loss, or which the CAG has come out with, both in the case of 2G and coal block allocation. So you really think that this judgment is some kind of a indication to the CAG not to indulge in these kind of presumptive losses in future?
No, the CAG, frankly, like anybody else, would go by their understanding of the law as it stands at a given time. Now, I think for anybody to say, well, I have the foresight and I have the vision of knowing what the Supreme Court will say 3 months or 4 months or 5 months down the road, that'll have to be an outstanding lawyer who can prophesy in that manner. But now that the judgment has been given, whatever any one of us is going to do or say or pronounce has to be within the context of this judgment.
Right.
Before this judgment came, there was another judgment, and that was the 2G judgment.
Right.
The 2G judgment, other than actually addressing the issue of licenses, gave the broad principles as well, which broad principles have not been accepted in this. So there we are. Now we have to follow the 5 judges.
No, it's very interesting. Earlier, Vikas Singh was saying that you people should have actually gone to the Supreme Court on a revision of the revision petition on the 2G judgment itself. And in fact, this opinion also was to some extent asking them that is auction, what you did earlier with the 2G spectrum, was it not right or wrong? Why did the government refrain from doing that?
No, that's purely, and Vikas is a good friend, and he knows that this is part of the structure of decision making of the Supreme Court. the only way you can challenge a decision of a bench of the Supreme Court is either by asking for a review, in which case it goes back to the same bench, and the review also has a limited opportunity to reverse. Then there is a curative petition, which again means that the same judges have to sit back and decide the same thing all over again. And very few curative petitions actually succeed. Or somehow you find occasion to have the matter referred to a larger bench. This happens in the Supreme Court, but you then have to wait for an indefinite period. You never know in which particular case a bench would be willing, another bench would be willing to refer the matter to a larger bench, and then what time the larger bench will take to hear it. Therefore, the presidential reference has taken care of what our immediate concern was without actually touching upon the 2G decision. Immediate concern has been addressed, and I think this was the quickest and fastest way in which we could have done it.
Mr. Vikas Singh, quickly, do you think this opinion, see, the government is seeing this as a vindication of their policy on the coal allocation also. Do you think they are justified in believing that this is a vindication?
Well, you know, my views have been very clear on this. In my view, this government always had the authority to decide how a natural resource is to be, and ultimately, you know, you have to look at what kind of natural resource and to what use it is being put to. If a natural resource is ultimately being used for the larger public good, or it is being used to create infrastructure, then the treatment can be very different. But if the natural resource is just a resource which is to, you know, earn revenue, then the treatment may be very different. So this power the government always had. Supreme Court has merely clarified that this is how it should be done. So I don't think that the government ever had
I entirely agree with what has been said before, except that I look on it as that you have to put it in the context of current day politics.
You continue to believe that it's a blind man and an elephant.
This judgment specifically, that people are picking and choosing what they want to hear, the government and everybody else.
No, but as far as the coal allocation is concerned, as far
as the coal allocation, the question is different. The Prime Minister in 2004 said it should be publicly auctioned. Why wasn't it put into place till 8 years later? Now the government has a series of explanations. Now it's up to you to whether you accept those explanations or not. The manner in which Mr. Raja brought forward the cutoff date, the manner in which 2G licenses, I don't think anybody can justify that. Why would Mr. Raja have spent 15 months in jail? The issue is slightly different. You know, the fact is this government has been under attack from not just his political opponents, but a whole lot of other people for misallocating and underpricing natural resources. There is a report which has been prepared by Mr. Ashok Chawla, former finance secretary, a list of bureaucrats, for reasons best known to the government. That report has not been made public, though there are hundreds and dozens of copies of that in public circulation. The question is, the government is on the back foot because it is under attack for not having allotted and price natural resources in a transparent, fair and a reasonable manner. And therefore today, everything that the Supreme Court has said and everything Mr. Salman Khurshid has said, everything Mr. Vikas Singh has said, we all agree with. But the point is, why didn't this wisdom dawn on our great leaders earlier? When all this gafla, I mean, that's why you have accusations of crony capitalism. That's why you have ministers and their friends and who've been the beneficiaries. And not the people of this country.
Paranajoy, we have completely run out of time. It's very evident that the government feels vindicated after this decision, but as Paranajoy was rightly pointing out what had happened in the past, hopefully after this we will see more transparent decisions being taken, and as far as natural resources are concerned, there is what the Supreme Court has said will be, and the common good will be the ultimate factor. Thanks to all my guests. Thank you, Mr. Salman Khurshid, Mr. Vikas Singh, B.K.Syngal, and Paranajoy Guha Thakurta. Please keep watching. We'll come back with another issue on the big picture, same time on Monday.